Hello, and thank you for joining us today. We're going to talk about sales and F&I compliance regulations, what to expect in 2014. My name is Randy Henrik. I'm DealerTrack's Regulatory and Compliance Counsel, and I have 35 plus years in consumer credit. And I've never seen a revolution in consumer credit the way we have the past couple of years, and that's because in 2010 the Dodd-Frank Act established the Consumer Financial Protection Bureau, an independent agency that has responsibility for 19 consumer protection laws. Franchised auto dealers are exempt from the CFPB's supervisory, which means audit, regulatory, rulemaking and enforcement authority, but lenders are not, particularly right now, lenders with more than $10 billion in assets. The CFPB started looking at indirect auto finance in 2012 and made a big splash in March of 2013, issuing a guidance, which is a statement of policy, that didn't require any comments, and it found that dealer discretion to mark up buy rates of lenders equals credit discrimination. It reached that theory under a disparate impact theory under the Equal Credit Opportunity Act. The way a disparate impact theory works is you take a facially neutral practice, marking up rates, but it has a disparate effect on protected classes of persons under the Equal Credit Opportunity Act: race, color, religion, national origin, sex, marital status, age, receipt of public assistance, or exercise of Consumer Credit Act rights. It would not disclose its statistical methodology in doing so, and it avoided two key elements of a disparate impact analysis, which are that rate differentials that are explained by significant, legitimate, non-discriminatory business purposes have to be taken out of the equation, regressed from the statistical analysis, and unless the agency can find those legitimate reasons to be incorrect, those transactions don't show discrimination. Their position is that dealer discretion equals discrimination. They also concluded, wrongfully I think, that lenders are creditors under Reg B and they're responsible for disparate impact credit discrimination by dealers. Effectively, compensating dealers for higher markups is unlawful if the dealer rate markups create a disparate impact, even though you don't know if a disparate impact is created until you do a statistical analysis well after the fact. The CFP believes, quite frankly, that discretion in dealer pricing equals discrimination, and their goal is to replace dealer participation with flat fee pricing. Lenders have had different reactions to the CFPB. They've pushed back privately in discussions with them on the legal shortfalls of the guidance. But many lenders are following the guidance because they're concerned about large penalties the CFPB imposed on other lenders in consent decrees in 2012, over $200 million in some cases. They don't want to be the next consent decree, so they're following the guidance on pressing dealers for ECOA compliance and are auditing dealer portfolios. A number of lenders claim that dealers they dealt with have a disparate impact in the contracts that they've bought from the dealer. And although it's unclear what methodology they've used, because we don't even know what methodology the Consumer Financial Protection Bureau used, they have, in one lender's case, cut off a dealer or a number of dealers who they reached this conclusion on. I ask, is one lender a statistically significant sample of a dealer's overall practices? You send your contracts to multiple lenders. And as I said, the CFPB guidance and probably these lenders' analysis failed to regress out deals where the rate difference is non-discriminatory and based on a significant business purpose. And that's a critical element of a disparate impact case. No lenders have challenged the CFPB in court yet. We may see that, we may not. But what's a dealer to do? Given the way lenders are pressing equal credit and fair lending, the First thing is, it's very important that you adopt and implement a robust fair lending ECOA policy, and particularly important are training and monitoring. Consider establishing a uniform markup amount for all customers, say the buy rate plus 150 basis points. Lower the markup only if one of a predetermined set of significant non-discriminatory business reasons applies to effect compel you to do so. Examples would be to meet or beat a competitor's rate, inventory reduction considerations, and other legitimate business purposes. A lender buy-down of rates or prohibition of a markup amount would be another. Document for every deal where you vary from the pre-established markup rate why you did it, picking one of the pre-established list of reasons. The Department of Justice endorsed this very approach in its Consumer Financial Protection Bureau hearing on auto finance in November 2013. In fact, the spokesman for the Department of Justice said, on discretion, ECOA neither requires nor prohibits discretion in pricing, and that you need to evaluate whether objective, non-discriminatory factors were used as the rate differential, taking a completely different position than the Consumer Financial Protection Bureau. What's on the CFPB's horizon for 2014? Well, right now they only have that supervisory authority, the authority to be able to go in and audit at any time for any reason or no reason for lenders having assets in excess of $10 billion. However, they can publish a rule and give themselves supervisory authority over larger participants for consumer financial services. And we believe what they will do in 2014 is attempt to do that so they get supervisory authority over all auto lenders. They're going to continue to press large lenders and captives for a consent decree to include an agreement for flat fee dealer pricing. And I believe they're going to obtain a consent decree from at least one or two national lenders who they're really pushing hard on. Now, they do understand the competitive implications of doing so, knowing that other lenders are not going to fall in line. That may delay the process or qualify it in some way, but make no doubt about it, flat fees are what the CFPB is looking for. They clearly don't want a court to rule on the legal issues addressed by the guidance because there are many legal shortfalls in their theories. ECOA does not, on its face, allow for a disparate impact theory. Creditors are not liable for the acts of other creditors unless they played a part in the discrimination or knew that the contracts were violative when they bought them. And in a disparate impact case, you don't know that because you won't know it until a statistical analysis is done well after the fact. Also, as I mentioned, they omitted the ability of dealers and lenders to give legitimate and significant business reasons for rate differentials. A captive is more likely than a large bank to litigate the CFPB's disparate impact legal theories because the loss of business to a captive could conceivably put it out of business. A large national bank could agree with the CFPB, and if it lost its auto finance business, it really wouldn't hurt its bottom line. So if we're going to see this thing litigated, and if we do, I think the CFPB will do a major backtracking. It would probably be from a captive finance company and not from a large national bank or other financial institution. How will this affect dealers? Lenders are going to continue to emphasize fair lending. They're going to audit your files. They're going to look for unjustified rate discrepancies for similarly qualified customers and assume that means credit discrimination. Dealers with an effective fair lending policy and who can document the legitimate business reasons for rate differentials deal by deal will be best positioned. It's possible, but I think it's unlikely, that the Department of Justice, which is also very involved in credit discrimination, may bring a disparate impact credit discrimination claim against a large dealer or dealer group. The U.S. Congress has written the CFPB to try to identify how it statistically reaches conclusions. The CFPB has effectively been stonewalling them, but they're not likely to intervene formally. But I can tell you this, we have 1,400 lenders on DealerTrack, and rate participation is not going to go away. The FTC is your main regulator on a federal basis. Let's talk about what they might do in 2014. Safeguards is going to be continue to be their primary issue, and they're going to come down hard on a dealer. If a data breach occurs, they came down hard on a dealer in Georgia last year who allowed 96,000 consumer records to be compromised when an employee put a piece of software on a computer in the dealership that allowed third parties to access it. The FTC has been very aggressive in bringing enforcement actions involving dealer advertising in social media, especially in social media and on the internet, even without customer complaints. They brought 7 20-year consent decrees in the last 18 months. They also went physically to the field at 11 dealerships and wrote warning letters for not putting the used car buyer's guide on all the used cars in the lot. Privacy notices will be scrutinized more closely. Your privacy notices may not say this, but many dealers do. We will never share your information. It's a good idea to check with your DMS provider to see what they're pulling out of your DMS and whether they're using it as a service provider or for their own interests. Because if your DMS provider is using that information other than to service you, that is sharing, and that would make a privacy notice that says we don't share non-compliant. The FTC has opened investigations on spot deliveries, and they may bring an enforcement action against a dealer on a bad spot delivery situation. They're under pressure from consumer groups to do that, but I don't have a sense that they see pervasive problems and will write a rule prohibiting or limiting spot deliveries. Other things, in 2011, the FTC conducted roundtable hearings on all kinds of alleged auto dealer disputes, and they've been very quiet. They haven't issued any rulings, meaning they haven't found pervasive problems in the industry, and I think you're unlikely to see rulemaking in 2014. Possible enforcement actions against dealers where bad conduct is found, even where it's not pervasive in the industry. Telemarketing is an example. In October, the FCC revised its telemarketing rules to require a prior written consent to use auto dialers or automated pre-recorded voice messages for telemarketing. Truth in lending, payment packing, other unfair and deceptive conduct on complaints that may be referred to them from the CFPB. The CFPB has established an online complaint hotline that lets consumers file complaints against dealers, and they are then referred to the FTC or state attorneys general. The good news is the FTC has not shown much interest in disparate impact credit discrimination against auto dealers, and a number of years ago declined to go in that direction. State attorneys general are your principal personal regulators. They are the ones who are going to be looking at your advertising, looking at alleged deceptive practices and complaints from consumers. There were numerous $100,000 settlements reached in 2013 for deceptive advertising and other acts. And they too have entered into a sharing agreement with the CFPB to obtain information from that consumer complaint hotline. This would be a good time to look at how you resolve complaints with consumers, because you don't want to get on the CFPB's radar screen on that hotline. And if it means giving a consumer more than they're entitled to, well, that's not a bad solution, because you don't want to be penny wise and pound foolish. Many state unfair and deceptive acts and practices laws are broader than Section 5 of the FTC Act and allow consumers to bring lawsuits too. All state attorneys general have guidelines about advertising for auto dealers. Get yours and follow it. Advertising is going to be very closely scrutinized. They are your primary enforcers for unfair and deceptive acts and deceptive advertising. Some other potential hot issues we see coming in 2014, where the regulators are, the plaintiffs' lawyers are, possibly some private class action litigation alleging disparate impact credit discrimination. Truth in lending and unfair and deceptive acts and practices claims. We've seen a lot of this for dock fees and other dealer charges or payment packing, as well as spot delivery situations. Private and regulatory actions based on deceptive sales practices or advertising increased in 2013 and will continue to be on the board for 2014. We've seen lawsuits alleging violation of privacy notice practices, and one court ruled that privacy notices are contracts. Again, I would ask you if you know where your data goes and if it is shared by your DMS provider. Those are the principal things we see. If you have any questions, here's my email and phone contact, and I'd be happy to talk to you about what you're seeing as well. Thanks for your time today, and I hope this presentation was helpful.